Good afternoon, everyone. I am Richard Rifkin. I'm the legal director at the Government Law Center, Albany Law School. And we're presenting this program in cooperation with the Community Foundation of Oneida and Herkimer counties. The center and the foundation have had an ongoing relationship. It's part of our Rural Law Institute. The idea is to promote community development in the area. Unfortunately, we have not been able to continue the activities in which we were engaged for some years due to COVID-19. We have had to change the nature of what we're doing with the Community Foundation. And this is one of the programs that have developed. We now have to do, of course, everything virtually. A couple of very short remarks, and then I will turn the program over to the speakers from who you really want to hear. First of all, let me say that all of you should have gotten the materials. We've sent links to the materials to each of you, so that if you need reference to the materials, go to your email box and you'll be able to find the links. I should also say that as part of the materials, there is a list of resources from Judge Lord. If you're looking for resources to follow up, you can find it there. I should also note that the program is being recorded. The recording will be posted. It may take a little bit of time, but it will be posted on the website of the Government Law Center. You'll be notified when it's up, and if you want to go back and rehear the program or any part of the program, you will have the opportunity to do that. If you have any questions, please use the chat box. Christina Alberto from the Government Law Center will be monitoring the chat box, and she will be able to pass on to the panelists any questions that you may have. We have three terrific speakers today. Judge Nancy Lord, who has really helped put this program together. She has been a bankruptcy judge now for just about a decade. And then two attorneys from Central New York, your area, Richard Weitz and Frank Brennan. And Richard's going to be talking about a new section of the bankruptcy law, which can prove very valuable to small businesses. And Frank's going to speak about negotiations and efforts to try to resolve problems staying out of the formal bankruptcy proceedings. So with those remarks, I now turn the program over to Judge Lord.
Good afternoon. I'm so glad you could all be with us. One correction, Richard, Dick Weiss is going to speak about tips for negotiating with creditors to avoid bankruptcy, and Frank Brennan is going to talk about sub 5. And I'm gonna poke my head in now and then. We'll start off with Dick Weiss. This may be in reverse order of the materials, but we'll start off with Dick Weiss, who's going to speak about how you can avoid bankruptcy if at all possible. It's all yours, Dick.
Thank you. Good afternoon. For many people, bankruptcy is a scary concept, even though from a legal point of view, it's just another tool that a borrower has or a debtor has to help negotiate and or have a court intervene in making adjustments with their creditors. Many people have told me that they hate the idea of bankruptcy, but when we go through what it can do, they sometimes change their mind. My portion, however, is to deal with people who are trying to avoid filing bankruptcy at all costs. I'll preface it by saying that I think before you try and negotiate your way out of all these deals, you owe it to yourself to consult with a bankruptcy attorney to get an idea of what a possible bankruptcy outcome would be. Because then you can measure your negotiation results against the bankruptcy results and decide whether the time, expense, and agony, so to speak, of a bankruptcy is better or worse than the time, expense, and agony of negotiating with your creditors. With that said, let's talk about negotiating with creditors. And the first thing is, I call it what is the ask you're going to make your creditor. Presumably, you have been unable to stay current on the obligations, whatever that obligation is, and you're either starting to get calls or you're going to reach out in advance and try and negotiate with creditors. In the real world, most people don't reach out in advance, so you might get a call from a creditor. The first thing I want to reassure you is it's okay to tell the creditor, I need some time to think about it, can I call you tomorrow? But make sure you call them tomorrow. The judge, bankruptcy judge in Albany, Judge Littlefield, is fond of saying that two things a debtor owes to their creditors: money and information. The less money you have, the more information you have to deliver, and sometimes vice versa. But that's a good rule of thumb. So when you're going to make the ask, it's important to understand that different creditors have different constraints about what they can say. And on my materials, I just started with the bank lender because typically that's the first person you call. Now, you should know that banks normally can deal with a loan for up to 90 days without getting a payment before they have to charge it off. So in today's world, after about the 30th day, you're going to start getting a call perhaps from your bank officer. So my feeling with the bank is if you can't make the payment, call the bank officer up on the 30th day and say, look, I know I missed my payment. I know you're under some constraints. I know you get really nervous if I miss the next payment. I'm going to try and get a payment to you, so I'm only staying 1 month behind. That gives you at least a month of cash flow. Remember, if you make a promise to your bank account representative, keep it. And if you can't make the promise, say, I don't know how much I will get you. I will keep you, and I will call you every week or whatever. Because one of the things that really hurts the negotiation process is if you make a promise to deliver a certain amount of money at a certain period of time, and then you fail. Because the person you're dealing with has reported what you said to their superior, and you make them look like an idiot. When you do your ask, of course, you should have a pretty tight budget. And I generally recommend that you take 10% off your income before you make a promise as a result of an ask. Even bank officers, however, sometimes can't give you a negotiation in the normal sense. For instance, if you have an SBA or an agricultural guaranteed loan of some kind of government guaranteed loan, the reason the loan was made in the first place is your credit wasn't enough to secure the loan. So let's say 80% or 75% of that loan is guaranteed by the government. The bank will not do anything that will imperil that government guarantee, because that's the only money they're sure of. So many times you speak to a loan officer and he says, well, I got to make a presentation to whoever the government guarantor are. And those presentations and that process can go on for a long time. Please remember to make the payments while that process is going on. Or some payments, ask the bank officer, what payments do I need to make so I don't scuttle this entire negotiation? And you also have to remember that at the end of the day, on these government guarantees, if you've personally guaranteed it, but it's a business loan, the government has the right to come in and get any defaulted money, particularly when they pay off that 75 or 80%. So if they have to make the payment, you can't pay them back. At some point in the future, they will come looking for you. My record now is 6 years. And even though many attorneys will tell you, well, 6 years, the statute of limitations for breach of contract is over, you don't have to worry. Technically, that's true. Unfortunately, the government has decided and passed the appropriate legislation that for government guarantors, the statute of limitations starts when they acquire the loan, which typically doesn't occur until they make the payment, which typically doesn't occur until years after. So I've had cases in which it's been 10 years since the matter we thought was behind us. The government guarantor entity is contacting the client and saying, well, even though it's more than 6 years, for us, it's only 2 years. We just got the papers 2 years ago. So that's an issue. Sometimes you can negotiate a mortgage modification and it's recorded. Now, there are some issues with intervening creditors. I'm not going to get into the law, but there are some issues. Some lenders want to protect themselves by doing a formal mortgage modification. Sometimes the government requires that as part of its documentation process. There are fees with that. So before you say yes to whatever is suggested, ask, are there going to be fees to this? What's it going to cost me? And see what happens. Sometimes the loan has been packaged and sold to a trust as an investment vehicle. Now, this generally happens more frequently with residential loans, but not always. And then it's almost impossible to get a negotiation going because the person you're talking to has no authority to negotiate with you. So, that's something you want to find out if you can. So banks are generally the first people to work with. Generally, they're the most reasonable unless there's a government guarantee, and then they have that problem of not wasting the guarantee. But there you have it. The next group I had was vendors. I just picked vendors as a group. Vendors are very much like you. You may not believe it, but vendors owe money too. And so if you think about from the vendor's point of view, any dollar they can collect to you, they've promised to 5 or 10 of their creditors. They're less likely to negotiate with you if you stop doing business with them. Some people think, well, I'll just stop doing business and go somewhere else and start doing business with another vendor and see how long I can go before they ask for payment. And that's okay. If you can find another vendor who's suitable in terms of price and delivery, that's okay. That's a strategy. But the other strategy is if you want to keep this vendor for whatever reason, you like the vendor, you like the vendor's products or services, whatever it is, there the negotiation is a little more complex. Generally, I found that if you can prepay for the next delivery of whatever it is and offer something against the back, that will open the door to continuing that vendor relationship working with you. How much? It all depends on the vendor. Let's say you've got a bill for $20,000 because you haven't paid for 5 months. And let's say that you normally are paying $3,000 or $4,000 per order. If you can scrape up the money for that $3,000 or $4,000, even if you throw 500 bucks on it, I mean, they will argue with you. But from their point of view, if I can get an order paid, move inventory off my warehouse, get cash for inventory and cash on the back, that's a good deal. And I will mention that you can have an attorney do all these negotiations for you too. Some people want to try it themselves. There's no magic. You just have to remember that don't be pulled into playing what they want you to do. You have to stick to your budget, stick to your ask. And if they threaten they're going to start a lawsuit, you have to say, I'm sorry, that's the best I can do. If you think getting a lawsuit will get you any better results, what can I say? If you get a credit collector calling you, you have a little more leverage, even though they are a lot more brutal in their statements to you. And the reason I say that is that a credit collecting agency is a commission agency. They get paid essentially as a portion of every dollar that goes in. If they start a lawsuit, they don't get paid that month. And in fact, depending on the relationship, they may not even be the one to start the lawsuit, or they're going to have expenses and there's a cap on the expenses. So if you're getting really heavy pressure from a credit collector, know that whatever dollar you can send them is going to earn the person you're talking to some commission. It may be a bonus based on how much they collected that month, which points out that if you're talking to at the end of the month, you might do a little better than earlier in the month because they're trying to get to their quota, but that's it. They will tell you all sorts of things about how you have to do this. If you don't do this, your credit record will be destroyed. Well, your credit record is going to be destroyed no matter what you do. That they'll sue you immediately. The cost of starting a lawsuit in New York, depending on where you do it, I say is $1,000 to $1,500 between the filing fees, getting the attorney to draft the complaint, serving the matters, getting it before the court. And getting before the courts today in the world of COVID is almost an impossible task to get affirmative relief. And then if they get a judgment, having the sheriff go and seize your assets is almost impossible. So right now you have a little bit of grace period. The advantage that a judgment gives them is they can go raiding your bank account. So if somebody's going to get a judgment against you where they can raid your bank account willy-nilly, that probably tells you that you're closer to bankruptcy than not. In the same way that if someone starts a foreclosure, someone starts a lawsuit. Now, just because a lawsuit or foreclosure has started doesn't mean the negotiations are over. It just means your time and your ability to negotiate more time is running slim. I will point out that right now, foreclosure sales are not happening in New York State. I read that under the Biden proposal, whether it becomes law or not, they're talking about a September 1 delay at least for evictions and foreclosures. So who knows? But you have to know that when you're talking to someone, what can they do to you immediately if you don't cooperate with them? If they have a judgment, what they can do is they can go after your assets. What if you've got taxes? Well, real property taxes are a funny animal. For the first year, the town that assesses them, they're the party who is due the money, and they have no negotiating room at all. You either pay or you don't pay. If you miss the deadline, there's interest, there's penalties. They can't do anything. Typically, in most New York counties, after a year, the town sells that bill to the county. The county gives them the money, or doesn't give them the money, but the county buys it. And then the county has a couple of years before they can start tax foreclosure on your sale. And some counties have passed legislation that allows a negotiated payment. They can't change the amount that's due, but they can negotiate the timing. Some counties will give you 3 years as long as you stay current, which gives you a little bit of relief. Other counties will give you 2 years. It all depends on the county. But know that if you can't pay your tax bill, there's no point in calling the town supervisor, who may or may not be your friend. There's not too much they can do. And even when the county gets it, they really can't negotiate the amount or the interest. You might be able, if you come up with a payment scheme that they work and they've passed the appropriate legislation, be able to do something on penalties. Let's talk about the IRS in New York State. Well, depending on your business, hopefully you're making all your trust fund payments. The trust fund payments are those portion of wages that you're withholding to remit to the state or the feds on behalf of your employees. And you really owe that money. And if you don't pay it, it's called a trust fund violation. And the government takes that stuff very seriously because in effect, you're stealing from the government. So trust funds are a problem. They're dealt with in bankruptcy in terms of paying and timing of paying, but sometimes the collector you're dealing with at the state or the feds is going to be much harder, pushing you much harder on your trust fund payments. And at that point, you might have to retain an attorney. Income taxes, they'll come after you. Depending on the collector, they'll push or not. Some of these tax collection settlement companies are good, some aren't. Generally, the way it works is you come up with, an offer of compromise, give all your financial information. A lot of people you see on the ads are dirt broke, and the tax entity has to make a decision about do they collect money now or carrying something for a few years where they know they're not going to get any money. That's kind of a hit or miss thing. There are accountants who specialize in negotiating with the taxes, and if you are intimidated by dealing with tax entities, which I understand they're pretty intimidating, generally they have no sense of humor. You may hire an accountant or an attorney to do this work for you. Some people I didn't put on the list, the utilities. New York State has a utility program. A lot depends on whether or not the account is in your name individually or in your business name. You got a different department. Your ability to negotiate some time is harder for businesses, but they don't want to turn you off if they can avoid it. And particularly in COVID, they're being encouraged not to turn people off. So don't be afraid if you can't pay the utility bill to call ahead and say, here it is. I know you get tons of mail that are saying Dunning letter, Dunning letter, Dunning letter, and you want to throw it all away. But the utilities are one group that you really have to deal with. Some people just stop answering the phone and just rely on their voicemail to decide who they want to call back. That's okay too. But it's one of these things where the longer you hide, the deeper the hole, the harder it is to get out. I think I'm just about out of time. But I do want to say that if you start from a process of knowing what the bankruptcy outcome could be, and you're measuring along the way what people are demanding, there are many negotiations where, in the end, you have to file bankruptcy. So that's why I'm saying check in early first with a bankruptcy attorney, because why spend 3 or 4 months in personal suspense and agony and worrying about something happening to you if bankruptcy ultimately is going to be where you are. I've had people who have rejected bankruptcy and spent a ton of money on attorney's fees and stayed out of bankruptcy and are happy that they spent that money. But from a clinical point of view, if they had been objective about it, they would have been faster and cheaper to have filed in bankruptcy. If you have any questions, I think you can put them through the chat room, but I think I'm out of my allotted 18 minutes. And so I'll turn it back to Judge Lord. Thank you.
Thank you very much, Dick. I'm going to speak for a couple of minutes about traditional bankruptcy options, or at least bankruptcy options that you were limited to until last February. I do want to say that I think both the attorneys on the panel, and I will say, when I was an attorney and I see it as a judge, typically debtors or businesses wait too long to go talk to an attorney. And because the earlier you go, the better off you go. And sometimes if you wait too long, it becomes almost impossible to deal with. And so whether or not you're gonna try to do an out-of-court workout, which you might want an attorney assisting you, or you're going to file bankruptcy where you think you may have to, you need to go to an attorney earlier than later. With respect to the different types of relief under the bankruptcy code, there's Chapter 7 that we know as the liquidation. It's available to individuals, corporations, limited liability corporations, and partnerships. It is what it is. It's the end of the business. For a business, you can close a business or walk away, or you could give it a decent burial by filing for bankruptcy. And obviously for an individual, it provides significant relief. The goal for an individual in filing for bankruptcy is to get a discharge from their dischargeable debts. A Chapter 7 trustee is appointed. The job of that trustee is to examine the debtor and the debtor's documents and see if there are any non-exempt assets to collect to distribute to creditors. And it's a fairly simple process. It may even be that you don't even see a judge unless somebody brings a particular contested matter. Otherwise, you might not even see a bankruptcy judge. There is the traditional Chapter 11. Again, available to individuals, corporations, limited liability corporations, and partnerships. The point there is to do an adjustment of debts pursuant to a plan of reorganization. It's typically used to reorganize and retain a business, but can, and often, and much more so the last few years, results in a partial or complete liquidation of assets. So there's such a thing as a liquidating plan of reorganization, although that doesn't sound consistent, but it is. It involves a lengthy and expensive process, and often for a small business, it's until, as I said, until recently, didn't make a lot of sense, and because it was just too expensive. Chapter 12 is specific to providing debt relief for family farmers and family fishermen with regular income. It involves proposing a repayment plan to make installment payments to creditors over 3 to 5 years. And the Rural Law Initiative of the Government Law Center did an extensive program on Chapter 12 in October of 2019. And you can, I believe, see that program in the materials, or at least the materials on the website. Chapter 13 is for an individual, self-employed, or if you're operating as an unincorporated business. It's sometimes called a wage earners plan. Debtors with regular income propose a repayment plan to make installment payments to creditors over 3 to 5 years. The debtor remains in possession of its property, his or her property. There are debt ceiling limits. That's why you'll sometimes see an individual in Chapter 11 because their debt exceeds the limitations for eligibility to be a Chapter 13 debtor. There's a Chapter 13 standing trustee, and this is often utilized as a vehicle to save a home. Again, sometimes challenging because if you weren't able to make your regular mortgage payment, it's obviously going to be more challenging to make your regular mortgage payment and catch up through payments to a trustee on back payments, but sometimes it works. also in Chapter 13, and in my court, I do it in Chapter 7, or in an individual 11. My court in Brooklyn and the Northern District in your area has a loss mitigation program where the judges are involved with attempting to get loan modifications through the bankruptcy case. It's sometimes less frustrating for a debtor to do a loan modification in bankruptcy than it is outside. Outside, you can't get anyone on the phone, you can't talk to the same person twice, you don't get the same story twice. When a judge is supervising it, you seem to get people talking to each other consistently, and you can see whether you can modify a mortgage. For a variety of reasons, none of these options worked very well for small businesses. We had a small business, and we do have a small business provision in Chapter 11, but it with some strict deadlines, but it really did not work well. Congress added a new subchapter to Chapter 11. It went into effect in February of 2020, and it's designed to be and hope to be a successful prescription for aiding small businesses in financial distress. Frank Brennan is going to talk to you about it. Frank will also, I hope, tell you that he was hand-selected to the panels that were created for a new animal called the Subchapter 5 trustee, and he is one of them, and he's one of those in your area. Frank, I turn it over to you.
Thank you, Your Honor. Judge Lord accurately states that prior to the adoption by Congress and the implementation of the so-called Subchapter 5 within Chapter 11, was really made some dramatic changes for the benefit of small businesses, particularly in very substantive ways that really account for the nature of small businesses. They tend to be single member or single shareholder LLCs or corporations, or only a handful of shareholders. Prior to the adoption of the small business rules that the judge referred to, which went into effect back in 1994, those rules were largely procedural. They ramped up the timeframes within which debtors needed to file a plan. They did away with a document called the disclosure statement that was really an informative document, but added another layer of procedure that needed approval by the court and review by creditors before you could move the case forward. But the real substantive rules and law for Chapter 11's remained largely unchanged. So if you were Mom and Pop Gas Station Inc. in Oneida County, you were subject to the same rules to attempt to reorganize under Chapter 11 as American Airlines or Texaco. And though the rules, well, they may well have worked at a very macro level for some of those more substantial debtors, really didn't work well, and were either cost prohibitive, procedurally prohibitive, or the rights that were accorded to creditors or the obligations that were impressed on debtors really made trying to reorganize under those rules, absent some consent by creditors, very unwieldy, and again, a very expensive process to try and reorganize a small business that probably couldn't afford the freight for such an extensive reorganization. So in September of 2019, Congress passed the Small Business Reorganization Act, which took effect in February of 2020. And it made some very substantive changes. Unlike adding a few sections here, the rules for Subchapter 5 are now within their own subchapter. They are particular to cases that fit within the definition of small business cases, and really are much better suited for the majority of Chapter 11 cases that find their way into bankruptcy court, which are not the American Airlines and the Texacos and the Macy's of the world. world, but are, you know, the mom and pop Inc. Stores, gas stations, small businesses that you see throughout the country. One of the real substantive changes that was made was, as Judge Lord pointed out, is in a traditional Chapter 11 case, the debtor remains what's called debtor in possession, basically stays in charge of its own reorganization. So management generally stays in control, unless there are have been some bad acts by management, either prior to or after the filing of the petition. You would get a trustee appointed only in the event that there were some bad acts where there was some real concern raised by creditors or the court or the U.S. Trustee's office as to the proper operation, or whether there were some improper acts by management. Subchapter 5 introduced the concept of a Subchapter 5 trustee, whose role is essentially to act as a mediator. So while there are provisions that do allow the court in some circumstances to put that chapter, or give that Chapter 11, Subchapter 5, Chapter 11 trustee some greater authority to operate the debtor or liquidate the debtor's assets, those only occur in again, those rare circumstances where there's some fraudulent behavior. The intent of the Subchapter 5 trustee is really to be a facilitator between the debtor and creditors to try and come up with a consensual plan, a plan that all of the parties can agree to as a way to reorganize the debtor's business. The timeframes are tight. The Subchapter 5 requires that the debtor file its plan within 90 days of the filing date of the petition. It requires that the debtor file a status report within 60 days after the filing of the case, and that the court conduct a status conference early on in the case to determine, get a lay of the land and what the case is about, where it may be heading, what issues there may be that might be an impediment to consensual confirmation. So it really is a very hands-on and fast-moving set of rules, the idea being to streamline the process and hopefully minimize the cost as much as possible for small business debtors that, again, may not be able to shoulder the additional expense of legal fees associated with reorganizations. The chapter does away with additional expenses that traditional Chapter 11 cases require, including quarterly fees payable to the U.S. Trustee's office, which are based on the debtor's disbursements. It's a sliding scale of fees, but for a small business, the thresholds are relatively low. The fees start off at about $325 for disbursements in a quarter of up to $15,000 in disbursements, and ramp up pretty quickly from there. So again, for a small business being faced with quarterly fees to the U.S. Trustee's office of an additional expense of $650 or $1,000 or more on a quarterly basis could be the difference between successful reorganization and not. One of the really big benefits, though, that Subchapter 5 does is it gave the court the ability to confirm a plan, even if creditors don't vote in favor of it. And in Chapter 11, there's when you propose a plan, there's a classification system of classifying creditors based on the types of debt they have. And in the ordinary Chapter 11 case, you need at least one class of those creditors whose rights are being changed somehow by the plan to vote in favor of the plan. And that could be a difficult task, particularly in a small business case where there's a limited number of creditors. Maybe the secured creditor would prefer to exercise its liquidation rights. So obtaining confirmation by consent under the old rules could be a difficult task for most small businesses. Under Subchapter 5, the court has the authority to confirm a plan, essentially applying a fair and reasonable test, so that even if no creditors vote in favor of the plan, the court can nevertheless confirm the plan if it determines that the plan is fair and reasonable, provides adequate treatment for creditors, and adheres to certain protections that other sections of the code require for treatment for creditors. But this fair and reasonable test overcomes the problem of trying to get creditors to vote in favor of the plan. And one other issue for potentially for small business cases is some creditors in a small business case may not want to be bothered with participating in the case. So even finding creditors willing to cast a ballot to determine whether to confirm the plan may be an issue. So all of those procedural hurdles have been eliminated through Subchapter 5. There is still voting required on proposed plans in Subchapter 5, but really the voting is to determine whether or not the plan has been consensually or non-consensually confirmed. And the distinction there has to do with the timing of certain payments and who makes those payments, not whether the plan itself can be confirmed. So that's a fairly substantial and powerful tool. The other is, under a traditional Chapter 11, there was the idea I mentioned, classifications of creditors. There's sort of a hierarchy of payments and classifications of creditors based on the rights they have. So secured creditors have certain rights up to at least the value of their collateral. Tax creditors are accorded certain protections. General unsecured creditors fall into their own class. At the very bottom rung of that ladder is equity, ownership interest in the debtor. And there's a rule under the Bankruptcy Code that says, the absolute priority rule that says, no creditor in a junior class of a lower class has the right to receive payment on account of its claim unless every class ahead of it has been paid in full. And what would make that a very difficult and complication for small businesses to try and reorganize is, again, remember, equity is at the very bottom of that rung. So if a creditor or the U.S. Trustee's office objected to a plan that said current shareholders are going to remain shareholders in the new entity, in the reorganized entity coming out of the reorganization on the back end after the plan's approved, are going to get essentially shares or membership interests in that new entity, but not have to pay anything for it. They're going to get them just because they were the owners of the prior entity, the pre-petition entity, which makes sense. It's a small business. Who else but the current owners would be likely to want to step in and reorganize the business? Well, the problem with that is the absolute priority rule says not so fast. If a creditor objects to that equity owner receiving the ownership interest in the reorganized entity coming out of bankruptcy on the back end of the plan, then the court cannot confirm that plan because it would be in violation of the absolute priority rule. Subchapter 5 does away with that rule. And that's a very powerful tool because what it obviates is the requirement that equity, that owners of the debtor entity would have to come up with some money to put into the plan to try and make the plan work. Now, there's some appeal to that. It gives the owners some skin in the game for the reorganized entity and provides some monetary benefit to creditors, but it could be an expensive ask. A lot of small business owners have their life savings tied up in the business, and coming up with an extra $5,000 or $10,000 to throw into the plan to satisfy an exception to the absolute priority rule that allows you to essentially buy the equity in the new entity could be an expensive ask for small business debtors as well. As a result of the changes under Subchapter 5, that absolute priority rule does not apply in those small business cases, in Subchapter 5 cases. So that hurdle is eliminated. There's also a provision under Subchapter 5 that allows for debtors who have borrowed money against their home, for example, to come up with working capital or to invest in the business and had to give a mortgage to secure that debt, allows those mortgages to be modified to the extent that there's not enough value to fully secure that mortgage. So if there's, you have a $50,000 in equity in your home and you borrowed $100,000 against it and put a mortgage on the property for that $100,000 to invest in the business, under Subchapter 5, the debtor can modify the rights of that mortgage holder that loaned the money for the business investment, and essentially reduce the amount that has to be paid in full to the value that mortgage actually attaches to. So instead of it being a $100,000 mortgage that has to be paid back in full, it becomes a $50,000 mortgage that has to be paid back in full, with the balance treated as a general unsecured claim. That's a big difference between the prior statute before the adoption of Subchapter 5, because generally there were prohibitions on modifications of mortgages secured by the debtor's principal residence, regardless of the use of those funds. So again, in a Subchapter 5 case, Congress recognized, I think, that debtors often had to avail themselves of equity in their residence to come up with capital for the business. They weren't going to go out and find investors, and they may not have been able to find additional shareholders or members. And traditional borrowing for that business may not have been available based solely on the business's credit. So they were, small business owners were obligated, or essentially, if they wanted to invest in the business or have working capital, to borrow against their personal assets. And prior to Subchapter 5, they'd be stuck without being able to modify mortgages that secured that kind of borrowing, even if there wasn't sufficient value to fully secure that mortgage. So that's a pretty powerful tool as well, that's now available under Subchapter 5. Subchapter 5 also eliminated the role of a creditors committee. So under traditional Chapter 11, creditors, unsecured creditors would have the right, if there were a sufficient number that were interested, to form a committee and to speak with one voice on behalf of the unsecured creditors. That committee also had the right to employ counsel. And that counsel was entitled to be paid, but paid by the debtor, not by the creditor constituents of the committee. Unless the court for cause otherwise orders, Subchapter 5 small business debtors do not have to face the prospect of a creditors committee of unsecured creditors. So the idea of all of these benefits was to really streamline the process, shorten up the time period to file a plan, which puts the onus on the debtor and counsel. And to echo Dick Weiss's comments and the judge's comments, that a lot of businesses don't seek bankruptcy advice until it's really almost too late, often when a lot has already happened, and the ability to modify or deal with rights of creditors may be limited because their rights have now been fixed because they've gotten potentially judgments or they've already attached accounts. That's not to say that you seek that bankruptcy advice as the first alternative and resort immediately to a filing, because I'm a proponent that it should be the last resort. But you would be well served and better served to understand what the bankruptcy process is about and what it can and what it can't do before you get too far into default situations with your creditors, because you may be able to plan in anticipation of the potential for having to file, or take some actions, some proactive steps in the negotiation processes that Dick Weiss referred to, that will help you avoid or delay the need for a bankruptcy file. So seeking the advice, even if you are not in extremis and find the need to have to immediately resort to a bankruptcy filing, is a wise strategy, because again, more information rather than less is better, and you may avoid handcuffing yourself to some outcomes that, had you had the prior information, could have potentially avoided or at least ameliorated to some extent. So generally, those are the overall changes that are most applicable, sort of the highlights. There are procedural differences in terms of how distributions under the plan are made, depending on whether it's consensually or non-consensually confirmed. But in a nutshell, the goal was to substantively modify Chapter 11 for the benefit of small business debtors, where prior attempts had tweaked with some of the procedures, but really didn't address the substantive issues that made Chapter 11 in general a fairly high hurdle for most small businesses to work with it. So I think I may be getting close to
Well,
my,
you're fine. I just was having trouble with my mute, unmute button.
okay.
Thank
Okay,
you, Frank.
sure.
Let me just say that while there have been a lot of changes, that a subchapter 5, chapter 11 is still a chapter 11. You file chapter 11 and then there's an actual affirmative election if you want to do a sub 5. For the attorneys, for the debtor attorneys, if we have any on the phone, filing chapter 11 is not for the uninitiated. You need to know what you're doing. And you really need to know what you're doing in subchapter 5. Things move quickly, and lots of provisions that otherwise apply still apply in chapter 11. So I would urge you, if you're interested in this, to continue to, there have been a lot of programs in addition to this one, and I urge you to avail yourselves of those programs.
If I could just mention one other, we were talking about all of the benefits and the businesses that could benefit from Subchapter 5. There is one exception to that. There is one carve out for debtors that are not eligible to elect treatment under Subchapter 5, and those are so-called single asset real estate cases. So if you are a debtor whose sole purpose is owning real estate derives substantially all of its income from rents derived from that, but don't do anything else other than essentially own the real estate and collect the rents, those types of debtors are not eligible for Subchapter 5. But that's really about the only exception. I mean, there's another carve out for single asset real estate that involves properties consisting of fewer than 4 units as well. But those are really the only limitations on debtors that qualify as small business debtors under Subchapter 5 to have the right to make that election. So, but I do want to note that because occasionally you will have, that would be the kind of another usual instance where it's, you have a debtor whose sole purpose is essentially owning and operating the real estate, but no ancillary business to that.
Thank you. As Richard Rifkin mentioned, in the materials, there's also something put together for resources and various websites with respect to COVID and separately with respect to bankruptcy. So please take a look at that. I would tell you that things are changing all the time, and a good place to look frequently would be on the Governor Andrew Cuomo New York State website. I'm going to talk for a minute, again, with the understanding that things are changing constantly about what's going on with moratoriums and forbearances. Like Dick Weiss said, you need to know who your creditor is. Well, in the case of a mortgage, you need to know who owns your mortgage and who services it. With respect to residential mortgages, if you have a mortgage that is federally backed loan, the FHA federally backed loan, the lender or the loan servicer, as of now, may not foreclose on you until February 28th, 2021. For loans backed by Fannie Mae or Freddie Mac, they cannot foreclose until the end of this month, January 31st, 2021. These dates may be extended. And again, we'll see what happens with the Biden administration and what's being proposed. The CDC did a temporary eviction moratorium, federal CDC applying to rental units nationwide, and that was until December 31st. However, with the federal COVID relief bill passed and signed into the law in December, there was $25 billion of additional rental assistance put in that bill, and you or your client may see if you're eligible. If you have experienced financial hardship due to the coronavirus pandemic and you have a federally backed mortgage, you have a right to request and obtain a forbearance for up to 180 days. You must contact your loan servicer to request such a forbearance. And if you're in this situation, you want to do that immediately. The current deadline for single family FHA insured mortgages is February 28th, 2021. Again, these dates may be extended, but that's the date. With respect to the state, again, I urge you to go to the website for the governor, the state of New York website, and that site should be consulted frequently. I will note for you that recently, well, let me go back a minute. The governor had been issuing executive orders that he'd been extending with respect to, initially with respect to foreclosure, those stopped, and then with respect to evictions, which have continued. Recently, the legislature passed and the governor signed the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020. You can find the text of the bill online. It was signed into the law December 28th. And you need to fill out a hardship declaration, and those can be downloaded from the websites. You can go to the nysenate.gov website as well. With respect to residential evictions, the act placed a moratorium on residential evictions until May 1, 2021 for tenants who have endured COVID-related hardship. Again, you need to file a hardship declaration. With respect to residential foreclosure proceedings, the act also placed a moratorium on residential foreclosure proceedings until May 1, 2021. Homeowners and small landlords who own 10 or fewer residential dwellings can file a hardship declaration with their mortgage lender or servicer, other foreclosing party, or the court. With respect to tax lien sales, the act prevents local governments from engaging in a tax lien sale or a tax foreclosure until at least May 1, 2021, but your payments are still required and due to the locality. Again, with all of these moratoriums, there's no debt forgiveness, at least we haven't seen that yet. Maybe it's ahead of us in federal legislation. So when these moratoriums are up, there's going to be a lot of money that's going to come due at one time. That's when we think as bankruptcy judges, we're going to see an onslaught of cases. With respect to commercial evictions, and this was part of the governor's state of the state, he's proposed legislation to codify an executive order that he had entered and continued to extend the statewide moratorium on commercial evictions until May 1, 2021. Again, you have to show the COVID-related hardship. However, landlords will be able to have and will be able to continue to evict tenants who are creating health or safety hazards. The current executive order on commercial evictions and foreclosures runs through January 31st of 2021. But again, it may be that the legislature will pass the proposal of the governor. That's what I've got with respect to moratoriums and forbearances. And then we would open it up for questions.
I don't see anything on the chat function.
I actually got an email with questions
Sure, Christina.
with regard to credit card debt. There's a couple of questions. Do you want me to just ask them all at once, or how did you want me to ask the questions?
Why don't you hit us one at a time?
Okay, so one of the questions is, what is the ability to negotiate with the credit card companies? How much would they give up? What do you need to know about the account prior to negotiation? Example, interest and finance charges versus purchases.
I don't mind trying to respond to that. The ironic thing with credit cards are that you get a better deal if you default, which ruins your credit rating. It's counterintuitive. There's also the question of whether or not, if it's a corporate card, have you guaranteed it? Generally, the laws of the states in which they're incorporated, for instance, American Express is incorporated, I think it's in Utah or South Dakota, and wherever they're incorporated, the law there says that you automatically guarantee the payment on a credit card bill if you use the card. So you may be personally liable. How much are they willing to knock off? I've heard 5%, you pay 5% to be done. I heard 15%, you lose the card. The challenge is you might lose all your cards if your credit rating drops too much. And the reality is it's almost impossible to do anything in today's world without a credit card. Although now that travel is restricted, maybe it's not so important, but you can't rent a car without a credit card. Tough to get an air flight without a credit card. So you have to be careful. And then, some credit card companies don't care if you're not paying other credit card bills. So one possible strategy is to try and keep one card current by making the default payment. And the negotiators are tough. It's tough negotiation.
The next question is, when a lawsuit is commenced to collect, do the credit card agreements typically allow for adding in collection costs?
Yes.
Now, once there is a judgment for credit card debt, what is the ability to negotiate with the creditor/collection law firm handling the account?
After they have a judgment?
Mhm.
Well, everything's negotiable. Right now, it's tough to get judgment enforcement. Remember, a judgment just gives you the right to go to a sheriff in any county in New York State and say, seize property. But that right has been, the cat may be coming over here. That right may be cut off by many of the things that the state and the feds are doing in response to COVID. So the real issue is, couldn't they send a restraining notice? A restraining notice allows them to send a letter with a restraint and an information subpoena to a bank that they believe you have money in. And then the money is frozen in that bank until they can get the sheriff to go and execute against it. Restraining notices are allowed. I'm not exactly sure how different sheriffs in different counties are dealing with the restraining notices. Depending on the county, they may or may not, if they get a levy, move forward and take the account, or they might say, we're not doing any execution.
How aggressive are the collection law firms, typically downstate firms, on collecting on the debt once they have the judgment?
Well, remember, they only get paid a portion of what they collect. So how aggressive would you be if you get real money by collecting dollars and you get next to no money by not collecting dollars? But remember, it's the dollars they collect. So the negotiation there is more about how much cash gets me out of this problem than it is about the size of the problem. And they will say they want it all. And if you don't have any cash that is reachable, which many people don't, I mean, you might say, I'm willing to go borrow money from my parents or from my brother-in-law or for somebody if I can get this reduced to X dollars. They may require you to give them a financial statement to back that up. Remember, if you are giving a financial statement to a federal guaranteed institution, and that financial statement is materially incorrect, depending on whether they can prove intent or not, that would be technically bank fraud. So you have to be careful if they ask for a financial statement. And, a lot of times people don't want to share that financial information. So it makes it difficult to negotiate your way out of a judgment.
Last question. If the debtor fails to respond to collection efforts, how likely are they to come upstate to pursue contempt proceedings to require a response?
Well, the general feeling is that if you don't answer restraining an information subpoena, it means you're hiding something. If you've really got assets and they have a judgment, I recommend you consult the bankruptcy attorney right away. If you don't have information, why not? I mean, if you don't have assets, why not just tell them? If you're currently unemployed, if you have no money in the bank or next to no money in the bank, if you have no assets that are, you might have a house, but it's fully encumbered. There's a homestead exemption in New York, depending on your county, 100,000 to 125,000. Bank accounts, there's an exemption for, I think it's 2,200, 2,500. It depends on your income and some other things. I would say that 90% of the people who have judgments against them are what we call judgment proof. The creditor could not collect any money because all their assets are exempt. But again, without knowing that, that's why I suggest you consult an attorney once there's a judgment against you.
Thank you. Does anyone have any other questions? Anybody on the phone calls? Actually, another one just came in. What is the current?
Okay, we may have to make this the last one because it's now 1 o'clock. So we've exhausted our time, but go ahead, Christina.
What is the current status?
There's a cat. I've been trying to keep her off all day.
All right, now we can conclude. Go ahead, Christina.
What is the current status regarding discharge of PPP loans?
Well, again, PPP loans, like any other loan, again, would be subject to discharge. The question is, it's come up in that whether or not they have to be repaid. So that is more of the question. Let me see if anybody else wants to add anything. Some PPP loans, if you did certain things and kept your employees and kept them on payroll, they don't have to be repaid. They're also not included. They are not included in various sections of the bankruptcy code that have debt limits. They're not included in the debt limit. Let me just say something, add something to the sub 5 point for a moment. The debt limit on sub 5 was 2,725,000 and change, a very odd number. That was the same as a small business case in general. When the CARES Act came into effect, they raised the debt limit to $7.5 million. So that will cover many more businesses. That's due to expire in March, but that may be extended. And obviously, the higher the debt limit, the more sub 5s we'll be able to see. So PPP loans are not part of the debt limit. But then again, unless there was some fraud involved in obtaining the PPP, there's no reason why it would be non-dischargeable. I'm going to turn to the practitioners if they want to add anything.
Yeah, I can speak to that briefly. So there's really two aspects to the PPP loan program. One is forgiveness, and the debtor has to satisfy the criteria to demonstrate that it utilized the funds for the appropriate purpose within the dollar limits and within I think the original PPP program was 75%, no more than 75% used for payroll or 25% for non-payroll expenses. That's been adjusted. I think it's down to 60% because it addressed some wrinkles that made that threshold prohibitive for debtors in the hospitality industry. To the extent that the debt is not forgiven, you didn't maintain sufficient employment or keep enough employees on the payroll, so you now don't qualify for forgiveness, that debt is converted to a general unsecured loan. There is no collateral required for it going in. And again, as Judge Lord indicated, absent some fraud, the debt it would be dischargeable in bankruptcy. I'd note, though, some of those loans could have been, could get fairly expensive, and the time frame for those repayment terms generally was 60 months from, and there was a point in time in the process, whether it was from the advance or from the determination that the debt was not to be forgiven, of only up to 60 months, as opposed to some of the other CARES Act programs like the EIDL loans, the so-called EIDL loans that were capped at $150,000, but had a much longer repayment period, up to 30 years. So, in general, absent fraud and absent forgiveness by the SBA, a PPP loan would be dischargeable in bankruptcy, and if to the extent that it has not been forgiven through the SBA process.
Okay, I think that's it.
And let me thank all of the speakers. This was terrific. I know I learned a lot, and I hope everybody who was in the audience also learned a lot. We anticipate at least another program with regard to the Community Foundation project on which we're working. We will send notice around once that program is in place. I thank all of you for attending and wish you all a good and safe day and weekend and future. Thank you all.
Thank you.